Good evening, ladies and gentlemen. My name is Martin Radner from Radner Law Group. I've been involved in civil, criminal, state, and federal trials throughout my years of experience as a lawyer, and I'm going to be bringing you trial analysis of the very important trials that are sweeping over our nation. So first, I need you to do me a favor. I need you to like and I need you to subscribe to this channel because I have a partner who doesn't believe in what I'm doing and he thinks I'm wasting my time and I should be devoting my time and attention to trials, to court appearances, to files, to helping the firm. And we kind of have this debate. And I feel that there's a room for this. I think that a lot of people are looking for good content, good trial analysis from trial attorneys. So that's what I think I'm going to be doing. And I'm hoping that it'll be successful. So I need your help to go and disprove my partner. Anybody that has any comments about the videos, any questions, please leave them below. I'll do my best to get back to them. And if there's any trial analysis and specific trials that you want to hear or attorney presentations that you want to hear an analysis on, let me know in the comments below and I will do my best to address those. So today we're going to be talking about the Johnny Depp Amber Heard trial. Now, this happened a little while ago. It happened about over a year ago. But it was a very important trial. It was a civil case. It was a case for damages. And we're going to be discussing today the opening statements. Now, as a disclaimer, I don't take any sides. I don't like specifically Johnny Depp over Amber Heard. I don't like Amber Heard over Johnny Depp. Some people love Johnny Depp. Some people love Amber Heard. I don't have a dog in the fight. I don't really care. I'm just discussing the analysis of, we're going to be discussing the analysis of the presentations of the attorneys, and we'll be discussing some of the facts, some of the evidence. But today is just going to be limited to the opening statements. So I'm not saying either that I'm a better trial attorney than any of these attorneys that were present. Obviously, these are very good attorneys. They've gotten these clients. They've gotten these celebrity clients. I'm assuming they're getting paid well for that. So I haven't gotten that yet, but I'm just going to give you my opinion from my experience in trial. So what don't we see in all these televised trials? What we don't see is perhaps one of the most important parts of a trial, which is jury selection or voir dire. You have to be able to talk to the jury, ask them questions, and that's what happens during jury selection. And there's only really 3 times when you're actually able to interact directly with the jury. And jury selection is actually the time when the jury, the prospective jurors, can interact back with you. They can talk to you. So jury selection is so important. Some attorneys would say that it's the most important part of a trial, and it's something that we don't even see on these televised trials. So jury selection in this case was very important. First of all, you got these 2 big celebrities. Some people love Johnny Depp, some people love Amber Heard. So as the attorney for either one of those parties, you've got to know whether your jury has any biases. If you're starting off a little behind, a little ahead, you got to know that. You've got to figure that out during jury selection. Also, this is a trial for a lot of money, millions and millions of dollars. And if I was on doing the jury selection for the plaintiff side, for the Johnny Depp side, I would be asking questions like, are you comfortable awarding millions of dollars to a person? Some people have trouble writing that number down. And in fact, I just recently had a trial where I asked that question during jury selection. And one of the jurors, quite honestly, raised his hand and he said, you know, I just can't put that type of number down on the verdict form. It's just too much. I can't put down millions of dollars on the verdict form. And that's important to know. You have to know that when you're suing for millions of dollars, when you're going to be asking for millions of dollars at the end of the trial, you've got to know whether these prospective jurors are able to put that number down on the verdict form. So jury selection, especially in a case like this, is so important. And also what you find is that during jury selection, the good attorneys will already start sprinkling in things about the case. They'll start planting seeds in the juror's head about what this case is about and what you need them to understand. And a lot of times the judges are going to tell the juries, don't try your case during jury selection. I'm not going to allow that. Don't try to talk too much about your case. And the good attorneys will still be able to kind of sprinkle in certain parts about their case so that they can know where the jury stands and kind of start laying the foundation for what they're about to hear and try to get them on their side already. So unfortunately, we don't get to see the jury selection. And also just one other point about jury selection is a lot of times you may make a point during jury selection and then you'll come back to that point. So you'll ask the jury during jury selection, if I prove my case to you, will you be comfortable awarding millions of dollars to my client? And if they say yes, so then you can come back to that in closing argument. You can say, now you all told me during jury selection that you're okay with awarding a lot of money. I've proven my case. I'm expecting you to follow through with what you told me. And I think that's very powerful because you're kind of telling the jury, you told me already you're going to do this. I'm just asking you now to follow through and do that. So again, we don't see the jury selection, so we're just going to jump into the opening statements. Now, what are opening statements for? What's the purpose of opening statements? So strictly under the law, opening statements are just a time when each side tells the jury what the evidence is going to show. It's not a time for arguing your case. So we've already been working on this case for years, coming up to trial. Now we're at trial. We both know each other's cases, and both sides know each other's cases inside and out. At that point, they certainly should. And it's not a time to start arguing about why your evidence is better, why your witnesses are more credible, why you've satisfied your burden. That's not the time for that. It's really just a time to let the jury know what the evidence is going to show.
The evidence will show.
The evidence will show.
First of all, the evidence will show.
Because the evidence is going to show.
However, the good attorneys will always try to sprinkle in some arguments because they want the jury to start thinking that their side is winning and their side is better and their evidence is more credible. So if you watch these opening statements, and there's 4 of them because 2 attorneys on each side got to do the opening statements. They split it up that way, and we'll talk about that soon. But if you watch those opening statements, you'll notice that sprinkled throughout the opening statements are not just comments about what the evidence is going to show, which you see plenty of that, but you also see some arguments about why this is credible, why that's not credible, why what they're saying is not believable, and things like that.
Would anyone ever joke about that if there had been actual abuse? Much less ask yourself, would a sister ever joke with an alleged victim about being punched by her husband?
Ms. Heard wants you to ignore the testimony of these medical professionals who saw her in real time. Just as she wants you to ignore the testimony of the police officers who testified under oath who saw her on May 21st, 2016, without any injuries.
If it had been Amber's intention to use this article to detail the abuse that she suffered and that you'll hear about over the course of this trial, believe me, the article would have looked very, very different. She could fill a book with those details. She probably would have started out by calling out Mr. Depp by name. She probably wouldn't have published it in the Washington Post. She would have described in great detail the man who has described himself, the violent side of himself, as the monster.
Then we get to April 30th, or April 21st, 2016. Amber's 30th birthday party. She was going to turn 30 the next day. Pretty big event. Her friends had a tape that they put together of everybody giving her tributes. Johnny doesn't participate. They have a dinner and a party for her that night. Johnny says, I have a business meeting at 7 p.m. I'll be there after that. What kind of business meeting do you need to have at 7 p.m. when your wife turns 30? But that's Johnny, right? And he can't say that it was an important financial one because he'd fired his financial manager the month before when, as you heard from Ben, it was blaming him for all his financial problems, so he's the problem.
Those are really all arguments. And what I noticed, which was interesting, is that this is a trial where objections are flying. There's objections galore. You look at the witnesses when there's cross-examination or there's direct, there's objections from the other side all the time. And that's something that you generally don't find, by the way, with good trial attorneys. They don't like to object so much. And there's a number of reasons for that. Number one is that most of the time, the objection, even if it's sustained, which means that the judge says you're right, the objection is right, the attorney is just going to have to rephrase the question, and the same information is going to come out one way or the other. So what are you putting on an objection for, just to have the attorney rephrase the question, and the same information is going to get to the jury anyway? So the jury is just disturbing and disrupting the attention of the jury, and the jury doesn't like that much. They just want to hear the evidence and they want to move the trial along. So if you're constantly getting up and objecting, I don't think it's a good look. And I think that the more experienced attorneys let a lot of things slide because it's not so important. Now, obviously, if there's something important about the case that is not allowed to come in, the judge made a ruling about that, and it's not allowed to come in, and it might come in now, then of course you have to object because there's reasons why that piece of information, that piece of evidence cannot come in. Now, so those are the times for the objections, but just for regular leading questions or some of the objections that we find in this trial, the information is going to get out there anyway, and it's just disturbing and disrupting the attention of the jury. Now, another reason why you may not want to object so much as an attorney is because it looks like you're trying to hide something. And part of what you're trying to do with the jury is you're trying to tell the jury, trust us. We're going to be open with you. We're going to be transparent with you. We're going to be forthcoming with you. We're not trying to hide anything. We're just going to let the evidence talk. We may just help you, may help direct your attention to certain things, but really, if you just have all the information in front of you, I'm sure that you'll come to the conclusion that our side is right. So when you're constantly objecting, it looks to the jury like you're trying to hide certain information from them. It looks like that attorney, what does he have to hide? So that's another reason why you may want to think twice about objecting. Now, of course, this is a televised trial, so that also plays into how the attorneys act. I think the attorneys, my impression is that when you're being televised and when everyone's going to be watching you, you want to show that you know those rules of evidence, you know the law, and you're going to object when you feel it's appropriate, and to look like you're a tough attorney, and whatever people will decide based on your performance during trial. So I think a lot of that is really for the audience, and it's really not so important for the trial. Of course, there is a trial, so the judge has to make rulings, and there has to be a lot of sidebars. But I think generally speaking, you don't find as many objections as you had in this trial that you would have in a normal trial. Certainly not with more experienced attorneys, when the information is really going to get out there anyway. And by the way, if there's information that the court was very outside of the presence of the jury, or pretrial motions where the judge absolutely made a very strong ruling that certain information is not going to come in, and then an attorney tries to get that information in, that attorney can be sanctioned, that attorney can be reprimanded by the court. That's not what the attorney wants to do. So anything that's really damaging that the court made clear is not coming in, that's not coming in. So exactly when there would be an appropriate objection, it could happen once in a while. That's worthwhile making the objection, but as many of the objections that we had in this trial, I think is just mostly for the audience. Now, that being said, now that we're already in the arena where all these objections are going to be flying during the witnesses, so it's interesting that during the opening statements, there's not really objections being made. And there's certainly places, if they wanted to make objections, anytime that there is an argument being made by either side, the other side could have objected and said, Your Honor, that is not for opening statement, that's for closing arguments, and they're not allowed to argue during opening statements. Yet, we didn't find that. So I thought that was an interesting point. Now, something that you have to do during opening statements is certainly when you're going first. So Johnny Depp's team, their lawyers, they're going first. And there is a lot of evidence that's going to be coming out in this trial. Now, of course, you want to tell the jury about the evidence that you are going to be presenting and the ones that help your case. Of course, you have to do that, but you also have to anticipate and dispel the other arguments and from the other evidence that's going to be presented by the other side. You've got to do that, because if the jury's going to hear it, they've got to hear it from you, because otherwise it looks like you're only telling them half the story. So here, if you're open with them and say, we understand that there's evidence that you're going to hear from the Amber Heard side. You're going to hear evidence of this and the other thing, and maybe suggestions of abuse, and you have to dispel it. You have to tell them, we understand that, and there's going to be evidence that also shows you that evidence is not credible. But the point is that you have to anticipate, and you have to discuss all of the evidence, the ones that are on your side and also the ones that are against your side, the ones that make your case weaker, because the jury has to hear it from you. Otherwise they say, oh, you're not telling us the whole story, you're not being transparent with us, you're not being forthcoming, you're not being open, and that's damaging. You don't want the jury to start thinking that about you. And if you take a look at both opening statements, you will notice that there are certain parts of each opening statement which the other side did not address. And I'm wondering if that was an oversight, or if they didn't anticipate it. At this point in the case, they should already know all the arguments being made. Now, of course, you're going to have certain pieces of evidence which is not so important, so you don't have to discuss, but I felt that there were certainly a number of pieces of evidence that each side spoke about, that which was important and relevant, that both sides did not discuss on their own opening statements, which I think the jury could be thinking, I wonder why they didn't discuss that. What else are they hiding from me? Are they really being forthcoming or not? So that is something. Of course, the advantage on that is to the plaintiff, because he goes first, but then the defendant also, when they get up, they can also address some of the things that the plaintiff said, or any evidence that the plaintiff did not discuss, which may come out. The Amber Heard side should certainly address it and discuss it. Now, something else that we find during this trial, which was, I think, only for a televised trial, is that you find that both sides had two attorneys doing the opening statements. I think that's just for television purposes. Most of the time, one attorney does the opening statement. I don't think any judge would allow the opening statement to be done by two attorneys, unless you're talking about a very, very complicated case and there's just so many moving parts, and maybe it would make sense to have two different attorneys do the opening statements. But generally speaking, in most trials, there's going to be one opening statement by one attorney. It's not going to be split up. But in this case, it's televised. The judge understands that, and probably the judge understands that everybody wants to get their time in the light. So, let two attorneys do opening statements. Let them, get out there. Let them make a name for themselves. And why not? It's okay. You're allowed to do that. So that's also. Now, another thing to notice by the opening statements is where is each attorney standing. So all the attorneys except for one stood in front of the jury. Camille stood in front of the jury. Ben Rottenborn stands in front of the jury, and Elaine stands right in front of the jury. They all are standing essentially opposite the jury. Of course, you can't see the jury on the television, but you can tell that they're standing and talking directly to the jury. Now, Ben Chu, when he gets up, he stands by the podium, which is next to the counsel table, which is next to the jury. Now, part of what you're trying to do is you're trying to discuss the case with the jury. You're trying to make it as socially comfortable as possible. You don't want the jury thinking, oh, this is attorney putting on a case that he's representing this client and this is all serious. You just want them to feel relaxed. You want them to feel like we're just discussing this case over a cup of coffee right now. We can be in your living room for all that matters. We're just going to discuss it. And by Ben Chu standing by the podium, and there's so many barriers. You got the jury in the jury box. You've got the counsel table there. And then at the counsel table, there's Camille, Johnny Depp, and there's other attorneys behind them. And then finally you get to Ben, which he's standing by the podium, and you notice that he has to kind of turn himself sideways to address the jury, and his papers are over there. And it just looks awkward, and it just doesn't, the jury can be feeling like this is just not comfortable for us. We don't, if you'd be speaking to us directly right in front of us, I think it would have made a better impression on the jury. So that's something also that stuck out of my hand. Now also, what is very clear and obvious that Camille and Ben read their opening statements, and it was scripted, and they wrote it and they read it from the paper. Now, they were good at reading it, and they obviously were very familiar with it, but they wrote it down word for word. And I understand why you may want to do that, because it's a very important case, and you don't want to. There's a lot of very easy sidetracks that you could get off the path of what you're really trying to say. And if you don't have a script, then you may go too far off script. But I still feel that you'd probably be able to just have some bullet points and also stay on track that way. And also, again, when you have a case like this where it's being televised, there's a lot of publicity. You're going to make sure what your opening statement is going to say. You're going to make sure, you're going to think about that so many times to make sure that you're not going to go off script. So, I think that scripting, writing word for word, and reading a opening statement to the jury is just not going to connect with the jury as well. The jury wants, first of all, they see you've got this stack of papers, right? So Ben had a stack of papers, which was his opening statement written out. Then Camille had a stack of papers. So the jury can be sitting there, sheesh, how many papers do you have left to go? I don't know if I want to pay attention for this whole opening statement. And especially when you're reading it, it just doesn't seem as comfortable as if you're just having a conversation with them. You're just talking. And if you're just talking with them, they don't even know when you're going to end. As far as they know, this is your last sentence that you're going to say. They don't know how much longer you have to go. So when you come with a stack of papers, number one, the jury can already be losing interest because they see how many papers you're going to read. And also just reading it just doesn't feel so comfortable and as social as just getting up and talking your heart. So and it's very obvious that Ben Rottenborn and Elaine did not do that. They did not have it scripted. They did not have it written out. And you can just tell the way that you talk to somebody when you're just talking without scripted, it comes out more authentic. It comes out more real. And that's what you want to do with the jury. You want to connect with them, and you want to build the rapport. And a better way to do that would be not to script your opening statements and say it, and read it from the opening statements, reading it from the paper. Now, something that I've noticed in both opening statements, which I thought was fantastic, and that is that why are we here? Why are we stuck in this trial? The jury is sitting here. They're going to be sitting here for weeks. They're dragged into this dispute between this couple. It's a messy divorce. What do you have to be here for? Why can't you guys just figure it out? So what each side wants to do, and this is important in the trial, you want to tell the jury that this is not your choice to be here. You don't want to be here. If you had a choice, you would never have filed this lawsuit. So it's obviously easier for the defendant, because he's the one that got sued, to make that argument. So as a plaintiff, you've got to figure out a way to tell the jury that really you don't want to choose this avenue. You don't want to file lawsuits. So what Ben Chu does, which I thought was fantastic, is that he pointed to Amber Heard and he said, the only reason, essentially this is what he said, that the only reason why Johnny Depp brought this lawsuit is because she chose this. She chose to lie. And when you use words like that that she chose to lie, that means that she is choosing this path. It was not Johnny Depp's fault that he filed this lawsuit. He was forced, essentially, that's what he's telling the jury. He was forced to file this lawsuit. It was Amber Heard's choice to lie in that op-ed, and then he had absolutely no choice other than to file this lawsuit. And that's very strong. That's a very strong point to make to the jury, because you want to show them this is not your choice.
By choosing to lie about her husband for her own personal benefit, Amber Heard forever changed Mr. Depp's life and reputation.
But Ben Rottenborn does the same thing. He kind of turns it on them. He says to them, to the jury during his opening statements, that you're going to be hearing all about their relationship and the soap opera that this whole trial is going to be. You're going to be hearing all these gruesome details and hearing recordings and all that's going to go on during this trial. And he says, but this is the type of case, and this is what Ben Rottenborn says, this is the type of case that Johnny Depp chose to bring. So he's kind of throwing it back on Johnny Depp. Yeah, we don't think Amber Heard did anything wrong, and now you're going to choose to prolong and make this a spectacle, this whole trial into a spectacle about their relationship, about this whole soap opera. This is all Johnny Depp's fault. So Ben Rottenborn does a good job of putting it back onto Johnny Depp, saying it's really his choice that you're going to be sitting here hearing weeks of all this gruesome thing.
And you know what? I'm sorry for that. I'm sorry. I'm sorry that we're going to have to do that. I'm sorry that you're going to have to listen to all of it. And I'm sorry that Amber's going to have to relive that. But that's the case that Johnny Depp chose to bring.
And Rottenborn says, which I thought was a very cute tactic, he apologizes for that. He apologizes to the jury. He says, I'm sorry for that. Now, it's interesting because why is he saying, I'm sorry? This is Johnny Depp's choice. This is what he just said, that this is the choice that Johnny Depp made. And yet he's saying, apologizing essentially for Johnny Depp. I'm sorry that you're going to have to hear all that. I'm sorry that this trial is going to take so long. I'm sorry that Johnny Depp is going to turn this whole trial into a spectacle. So it's apologizing, but then again, it's kind of like saying, this is really what they should be saying. This is really what Johnny Depp should be saying, that he should be saying apologizing, and I'm kind of doing it for him. So it's kind of trying to win some points with the jury, I feel, and I thought that was a good point. Now, something that the plaintiff's side did not do in this case, which I think is so important to do in any case when you're the plaintiff or you're the prosecutor in a criminal case, and even when you're the defendant side, you have to do this. But certainly when you're the plaintiff side and you have to prove your case, that you filed the lawsuit or you're bringing these charges, you've got to prove your case. Now, the jury can be thinking, well, we know we're going to be hearing evidence from both sides. Now, how are we supposed to weigh this evidence? What is it? How much do you have to prove your case by? So they don't talk about the burden of proof in this case, which I thought was just glaringly missing from this case. In almost every case, as a plaintiff's side, you've got to tell the jury how much you have to prove your case by, because you have to tell the jury, look, you're going to be hearing evidence from me, and maybe this was done during jury selection. I always do it during jury selection. I do it during opening, and I do it during closing, because I want to remind the jury how much I have to prove my case by, and the jury, you tell me if I've proven my case. I believe I have. So it could be it was done during jury selection. I don't know. But during opening statements, it certainly should be reiterated to remind the jury. Now remember, the burden of proof in this case is such and such and such. So it's a civil case. It's not as great of a burden as it is in a criminal case. In a criminal case, we all know that it's beyond a reasonable doubt. The prosecutor has to prove the case beyond a reasonable doubt. And the prosecutor should say, I'm going to do that. And in this case, also, Johnny Depp's team should have explained what the burden of proof is and how they're going to satisfy that burden. And the fact that they didn't bring it up, and then the defense doesn't bring it up either. I felt like Amber Heard's team, their attorneys should have also said, by the way, something that they forgot to mention to you was that they have to prove this case, and this is what the burden is. This is a burden. They have to prove this case. And you should be thinking about that when you're hearing the evidence. And both sides, I feel, missed out on that point. Again, unless they mentioned it during jury selection, and still, if they mentioned it during jury selection, they probably should have mentioned it during opening and closing arguments. Now, there was also something else that Ben Chu said that stuck out in my mind, and that's what he said at the end of his opening statement. He said, ultimately, this trial is about clearing his name. That Johnny Depp wanted to win this case. You know why? Because he just wants to clear his name.
Ultimately, this trial is about clearing Mr. Depp's name of a terrible and false allegation.
I was thinking about that, and I think that that's a he shouldn't have just left it at that. This is a case that you filed. In the complaint, you said that you're suing for $50 million. And now you're telling me that this is just about getting his name back? Well, think about it. If you're on the jury and you're sitting there and saying, oh, this case is just about Johnny Depp getting his name back, so all we have to do is tell Johnny Depp that your lawsuit was correct and this was defamation, so we'll award you $3. And then you'll see that you'll get your name back because we all sided with you. No, we didn't give you a lot of money because this wasn't about the money. So really, the jury could be thinking that. So I think instead what should have been done is that you should that you could, as the plaintiff side, as Johnny Depp's team, you should say, this case is also about getting his name back, but make no mistake about it, this is also a case of damages. This is a case about the damage that Johnny Depp suffered because of the choices that Amber Heard made, and because of what she did, the tort that she did against Johnny Depp. That is what caused him all these damages. That's why we're asking for $50 million. So you've got to tell the jury it's not just about getting his name back. We're here for money. We're here because the damage that was caused to Johnny Depp, and he deserves compensation. And as the plaintiff attorney, you've got to explain to the jury, what does it mean, compensation? How do we compensate Johnny Depp for his losses, for the damage that was done to him? You got to explain that to the jury so they understand what you're really here for. It's not just about getting his name back, because then they don't have to put any significant number down on that verdict form. So that was that point that was missed, I believe, or overlooked and not mentioned during the plaintiff side. And if I was on the defendant's side, I would have gotten up and I would have said, this case is not just about getting his name back. This is not about that. If that's what Ben wants to make it, that's what Johnny Depp wants to make this case about just getting his name back. He sued her for $50 million. That's what the Johnny Depp, the Amber Heard side should have said. It says, don't make this like this is you're just above all the money and you don't care about the money and this is just about this. That's not true. You wrote in that complaint that you want $50 million from her, and that is I think would have been a very strong argument to tell the jury that they're not being forthcoming, they're not being honest, and that's something that you want to tell the jury that your side is being forthcoming, that your side is being transparent, and their side is not. So that's something that I believe should have been done also. Something else that Ben Rottenborn does, which I thought was good, specifically in this case, and that is that, like I said, I don't love the idea of reading anything to a jury. I think when you read it to them, it puts them asleep and they're not interested, and it doesn't create kind of a conversation feeling, which is what you want to do with the jury. But Ben Rottenborn reads the entire opinion piece, the entire op-ed. He reads it word for word, takes a few minutes to read the whole piece. But I think that, generally speaking, you don't love that doing that to the jury, but in this specific case, I think it was perfect. And the reason is that the Johnny Depp team is picking out 3 statements in that article and saying this is defamation. And part of the argument that Amber Heard's team is making is that it's taken out of context. If you just take one sentence out of an article and just flash it in front of people, they're not going to understand the context. So this is all about the context. And that's part of the argument that he's making. And therefore, he reads the entire article. And you know what? If it puts the jury to sleep, good. Let it put the jury to sleep, and then they'll realize, this article is not so bad. It's not so bad. It even put me to sleep. It's not a shock and awe. The whole thing is not a shock and awe article or an op-ed. And that's why I believe, again, he didn't do anything funny. He just read it word for word. He said it. He didn't try to speed up during the bad parts or go slow during the parts that would help him. He just read it to let them know this is boring. This is just a boring regular article. And you probably even fell asleep during it. So I thought that was a good tactic on his side. Now, also something that Elaine brought up in her opening statement was that one of the accusations that the Johnny Depp's team made and their attorneys made in their opening statement is that there's going to be evidence of these horrible pictures of Amber Heard being hurt. And they said that the evidence is going to show that those pictures were tampered with. Now that's a very bad look. Oh, look, you're trying to change the photos to make it look like you've been abused when that really didn't happen. That's very damaging. So what Elaine did in her opening statement is that she addressed that, and she said something, whenever you have one side of the attorney is trying to accuse your client of something that sounds terrible, what you've got to do is you've got to show that your client is no different than anybody else. And that's what she did. She kind of said, we're not talking about that she secretly manipulated all these photos and tried to change them. She did something that we all do on our smartphones. We all pull up the pictures and we don't like exactly the lighting or things like that. We start playing around with it also, but that's not called changing the editing the pictures. They can't discredit the pictures. The pictures are the pictures, and she didn't do anything that we all don't do. Once you put her with everybody else in the world, then it doesn't look so bad what she's doing. Also, another thing that Elaine did was that she said that Amber Heard fell in love with the Johnny Depp that we all fell in love with. Meaning Johnny Depp has this side in the movies where he just looks awesome. He just looks fun and charismatic and charming, and he's just this larger than life figure, and we all just love him from the Pirates of the Caribbean. And what Elaine was saying, yeah, we all do love him. You know, so did Amber. We all love him. Again, putting Amber with everybody else, we all loved him. But what we all don't get to see is the Johnny Depp off of camera, and that's something that we're going to let you know during this trial, what he was like, the monster that was after this camera. So again, putting Amber with everybody else, trying to understand the feeling why Amber would fall in love with him in the first place, because we all loved him. But then once you start to see who this person really is, then that's when she realized that this was an abusive relationship. Now, some very strong points that Elaine brought up in her opening, which the Johnny Depp team did not anticipate and did not discuss, was the fact that she couldn't have a password on her iPhone. This, I doubt, was a surprise to the Johnny Depp team, that they're going to make this type of argument. Again, like at this point in the case, they should already know basically every argument that's going to be made. That's very damaging. To tell one spouse to tell the other spouse that you're not allowed to have a password on your iPhone, on your smartphone, or you're not allowed to work. One of the things that she said, that she was not allowed to work. That is abuse. That's abusive. That's power. That's trying to control the other person. That's absolutely abuse. And once the jury can hear, oh wow, that is abusive. That's abusive behavior. Then you can understand from that. Well, then it would kind of make sense that he would also physically abuse her, because usually these abusers are all in one category of people that just abuse, and they don't know where to stop. So that was a very strong point that Elaine made. She was not allowed to have a password. She couldn't work. This is abusive tendencies, and therefore it's a reasonable inference from the jury to infer that Johnny Depp also physically abused her. And this is something that the Johnny Depp's team should have anticipated, and they should have brought up in opening statements. You're going to hear evidence that Johnny Depp did not allow Amber Heard to have a password on her iPhone. That's incorrect. You're also going to hear evidence that that's not true. So they have to dispel that. They have to let them know, and they have to dispel that. That was not done. Also, she kind of painted Amber Heard in a nice light. She said that really under the divorce, she was entitled to half the estate, which is, she said, $36 million, and instead she was only happy taking $7 million because it's not really about the money for her either. So that was also just kind of, when they're saying, oh, she got these $7 million, wow, $7 million, and Elaine was saying, she's really entitled to half of the estate. That's how divorce works. So she was really entitled to $36 million. Makes her look a lot better. So again, a lot of good things that we saw on both sides. A lot of things that perhaps were missed or oversights. But that was my take on the opening statements. So remember, please, to subscribe and like, so I can disprove my partner about these videos, and I will be able to continue bringing you this content and this trial analysis. Looking forward to next time.